Welcome to SpringLaw's Spring Forward Legal Updates webinar series. This series is designed to provide a comprehensive legal overview of key issues related to employment law and human rights in Ontario. SpringLaw is a virtual employment law firm advising on workplace legal issues for employers, employees, freelancers, and executives from a wide range of industries. We hope you enjoyed today's webinar and find it useful and informative. To reach our team, please visit us at springlaw.ca. And now to our presenters.
Good morning, everyone. My name is Marnie Baizley, and I'm here with Danielle Murray. We're lawyers at SpringLaw, which is an employment, labor, human rights, and contract law firm. We're a virtual firm based out of Ontario. For more info about our firm, you can visit springlaw.ca. And I will say that on our firm, we've got a lot of great resources. We have an award-winning blog, and I can say that because I don't write it very often. It is really amazing, and I do check it for lots of up-to-date info. So do visit our website and check out our blog. There's also a link to our newsletter there and information about our subscription program for employers, and an ebook for employees who've been terminated and are looking for more of a DIY approach to approaching their termination letter and severance package. We're thrilled that we have so many attendees here for this second wave workplace issues related to COVID. We're getting lots of questions from our clients and providing hopefully useful guidance on how to navigate all of these difficult circumstances related to COVID. So I'm going to hand it over to Danielle, and she's going to take us through our roadmap for today.
Okay, good morning, everyone. So this is the roadmap. Basically, what we're going to talk about today is mainly COVID-19 and how it's affected work and kids and family. We're going to talk about the infectious disease emergency leave, also known as IDEL, the new government benefits that have replaced CERB and that have recently been implemented, human rights protections for employees who are parents or caregivers to parents, and accommodations, employee accommodations, and then finally some takeaways at the end. And we will be taking some questions at the end. So, work and family. We know that, and we've been hearing a lot from clients that COVID-19 has had, as I'm sure you all know, serious impacts on employees, employers, and their family members. So we've seen significant impacts to employee schedules. We're seeing employees need flexibility in hours. Some employees, aren't comfortable going to the office. It's affecting their availability to work full-time hours. When kids or other people that they're caring for are home, it involves distractions from work if they're working from home. And again, some employees are unable to come to the office. So we're seeing, there's, especially with school having started, and some kids are going to school, some are staying home, and it's really impacting employees' ability to perform their work and their work requiring accommodation. So we're going to be talking about that some more today. I'll pass it over to Marnie, who's going to talk about the infectious disease emergency leave.
Okay, so I'm sure that you're all familiar with this leave at some level by now. As Danielle said, otherwise known as the IDEL. So the IDEL is an Ontario leave. We, as I said, are an Ontario-based firm that advises clients across the country. We're going to focus on Ontario today, and the IDEL, but there are similar leaves, COVID-type leaves in all provinces, and they function quite similarly to this one. But when we dig into the actual regulations, we're talking about Ontario. So the IDEL, you can just put me onto the next slide there, Danielle. The IDEL is an unpaid job protection on unpaid job protected leave, and as I said, it's similar in other provinces. We're talking about Ontario today. Okay. Okay, so the reasons an employee can take the IDEL, in the last while, this has really broadened. It used to be more specific reasons, such as a closure of a daycare has caused an employee to have to be home to care for a child. But it's, I think, the important general theme for today is that it is a quite broadly accessible leave. And we're going to talk about some of the more common scenarios that we're seeing from our clients and questions we're getting. So, for example, if an employee is in quarantine or isolation by a direction from a doctor, nurse, or Telehealth Ontario, that would be a reason the person could take the IDEL. If an employee is caring for a child or family member, an elderly parent, for example, because of a matter related to COVID, they'd be eligible to take the IDEL. If the school or childcare is closed because of COVID, or because the employee they chose not to send their child to school or the child to childcare because they have a fear of exposure to COVID, that would be another reason. And I popped in this handy link this morning, just again to reiterate that it's broadly accessible, the leave, and this link, Ministry of Ontario the website, has a lot of detail, and the family members are listed there. It's quite broad. It includes uncles, aunts, step parents, and it's a very detailed list and a handy reference that'll be updated as things change. More reasons why employees can take the IDEL. So caring for a child who is sick with COVID or who stayed home because of COVID protocols at the school, which generally means symptoms, and anyone with kids in school will know that list has narrowed slightly recently, but anyone with kids in school is obligated to do a health check in the morning, and then their children will get checked again at school. So it's quite a broad, a broad list, and if that means a child's home, that entitles an employee to the IDEL. If a child has a symptom that doesn't automatically require the child to stay home, but for precautionary measures, a parent decides or a caregiver decides that the child should stay home, that would entitle them to the IDEL as well. So again, greater flexibility for a caregiver to make that determination where they have concerns that are related to COVID. And again, we're focusing, on kids and schools and some of this commentary, but this does apply again to family members and those in the sandwich generation who are caring for elderly parents. Certainly, this applies as well, and we're seeing some of that go on. The length of the IDEL, there's no limit in terms of the length of the leave, and it can continue as long as the triggering event continues. So for example, if somebody is in quarantine or they are ill from COVID, it would continue as long as that triggering event continues. And the IDEL will be available as long as COVID-19 remains a designated infectious disease under the applicable Ontario regulation. In terms of how the leave can be taken, it can be taken in partial days, so days here and there, and there's no need for this to happen consecutively. So again, we're seeing this flexibility where an employee needs, they might have one child home one Monday morning and another child home Wednesday afternoon, and employers are obligated to accommodate this unpredictability as long as the need for time off is COVID related. If the leave is taken as a partial day, the employer must let the employee work and pay them, obviously, for the part of the day that the employee is not on the leave. In terms of an employee, proving their entitlement to the IDEL, employers can't require a certificate from a physician or a nurse. They can require supporting evidence that's reasonable in the circumstances to justify the need to be on IDEL. So for example, you might get an email from a daycare confirming that the child is not able to go to the daycare, and therefore obviously the employee needs to care for that child. And I would just say, if you have a sense that employees are abusing the IDEL, then really start to have conversations about why it's needed and document those conversations. And reasonableness is a concept that overrides everything here, and having an open dialogue with the employee about why they need to be off, and responding and taking their requests in good faith is important. While an employee is on IDEL, it's important to remember to continue their benefits. They have a right to be reinstated to their role, substantially similar role when the IDEL is done, when they're returning to work. They have a freedom from reprisal or any kind of negative or adverse consequences because they've taken a leave. So again, a reasonable approach by employers in taking their requests on a good faith basis and really trying to figure out how to accommodate the request that's coming from the employee. And as with other leaves, the time on the leave counts as active employment for the purpose of determining seniority or length of service. So it's as if they've been sitting in their chair or as if they've been in the workplace the whole time that they've been on the IDEL.
Okay, so I'm going to talk about new government benefits. I'm sure most of you are familiar with the CERB, and the CERB has been replaced with 3 separate government benefits. So it's really like the government has separated the CERB into three benefits, and combined, it's very similar to what the CERB was. And this is for people who are not entitled to employment insurance. So the first that I'm going to talk about is the Canada Recovery Caregiving Benefit. So this is, as we know, IDEL, as Marnie explained, IDEL is an unpaid leave. So that means that employers do not have to pay employees while they take this leave. And so employees can avail themselves of these benefits, including the Canada Recovery Caregiving Benefit. So if employees are on the IDEL for reasons related to caregiving, they may access this benefit, and they could be entitled to $500 per week for up to 26 weeks. And it's a bit less after tax deductions. It comes up to about $450 per week. So it's available to eligible Canadians who are unable to work because they must care for children under the age of 12 or other family members due to the closures of schools or daycares or care facilities because of COVID-19. So where school or daycares are open, but the child cannot attend in person due to being high risk, they can also access this benefit. Or if the usual caregiver is not available due to reasons related to the pandemic. So those are the main eligibility criteria. There is also the Canada Recovery Sickness Benefit. So this is if an employee has contracted the virus, that employee can have access to this sickness benefit. And it's $500 per week or $450 per week after tax for workers who are unable to work for at least 50% of the week because they contracted COVID-19, they're self-isolating for reasons related to COVID-19, or they have underlying conditions, or they're undergoing treatments or have contracted other sicknesses that, in the opinion of a medical practitioner or other person of authority, would make them more susceptible to COVID-19. So they can access this benefit for that reason. Finally, we have the Canada Recovery Benefit, which is the more general benefit. It's quite similar to what the CERB was. It's now open, as of last week, it's open for applications through the CRA. And employees or workers in general, self-employed or not, can have access to $500 per week for up to 26 weeks. This is for workers who have stopped working and are not eligible for EI, as I mentioned, or they had their employment or self-employment income reduced by at least 50% due to COVID-19. So the benefit will be paid in 2-week periods. So you have to workers have to reapply after every 2 weeks. And the thing that's interesting here is that you can get it if your income has been reduced by at least 50%. But if you've made more than $38,000 in the year, so on your income tax for that year, that person needs to reimburse the government 50 cents for every dollar earned above the $30,000 up to the amount of the benefit received. So you have to reimburse, but you don't need to reimburse for more than what you've received in this from this benefit. So if you calculate it with CERB, you could make up to $2,000 a month, and then in addition to that, you could make employment income of a maximum of an extra $1,000 per month. This ends up being about the same with $38,000 a year. So it ends up being about an extra $1,000, maybe a little bit more per month that you can earn in addition to the benefit. And then in addition to the IDEL, if the IDEL does not apply, although in most situations where employees need unpaid time off right now due to COVID-19, the IDEL will likely apply. But if the IDEL does not apply, human rights laws offer access to a broader range of accommodations. So employees or workers can say that they're entitled to a human rights leave, which we're going to get into a bit later. So accommodations, I'll pass it on to Marnie.
Yeah, so if for some reason an employee is not entitled to the IDEL, as Danielle said, they may be entitled for human rights code related reasons to the leave, and that would be related to typically care of a child or a parent. Again, that sandwich generation who's caring for a family member, they would have coverage under family status, which Danielle's going to talk about in a moment. But what kinds of accommodations would fall under a request for accommodation? This would be, for example, the need to work from home for some or all of the day, work reduced hours, or have some kind of flexibility in their schedule, reduced hours or flexible work week, or to just have their workload reduced to accommodate whatever the presumably temporary needs are related to COVID. So as I always say with accommodation requests, I think an open dialogue is very important. You can get creative about what you can come up with and document in terms of an accommodation plan, and what might work with a person's particular work schedule. Maybe that involves working later in the evening or earlier in the mornings to work around whatever their caregiving obligations are. But really is a two-way street between the employee and the employer to come up with a plan and communicate with each other to find a way to get the job done, and for the employer to be able to run their business and be able to rely on their staff to get the work done, recognizing that they really do have to accommodate to the point of undue hardship whatever request for accommodation the employee might be making. So in having that conversation with the employee about what is it that you need, you of course need to ask why are you requesting this accommodation, and they may say, look, I just need to work from home, I need flexibility, and they have an obligation to explain the why, and then the employer can assess the request, assess the reasonableness of it, and employers don't have to agree to every request of an employee. Again, it's got to be reasonable, and you've got to be able to still run your business. And I think there's often a solution that can come up between a dialogue between the employee and the employer. Some of the issues we're finding, like we've already covered, the kid-related, childcare-related, elder care-related reasons. Those are certainly permitted reasons why a person might need an accommodation. But what we are sometimes seeing is employees are just more vague about the reasons for needing to go on the IDEL. I don't think there's necessarily a whole widespread abuse going on with employees, but there's certainly a fear around COVID, and lots of employees just say, I don't want to come back, or I'm scared. And that puts employers in quite a difficult spot. And if an employer can say, look, we've got plexiglass in the office, we've got regular cleaning schedules, we've got all these precautions to make sure the workplace is safe. Can you please explain, the basis of your concerns so that we can address them, further address them, or we can try to further address them and go above and beyond what we've done to make the workplace safe. Then if the employer has checked those boxes, and it really does come down to just a fear of COVID, then you get closer to being able to take the position that the employee, if they refuse to return when they've been asked to return, despite all with all the precautions taken, you do come close to a job abandonment scenario there. Again, this is a tricky one, and we would recommend getting legal advice for sure in a scenario like this, but the employee does have an obligation to return. If the answer is I don't want to affect my CERB or my EI or my CRB, then that's obviously not an answer, because the goal is to get people back in the workplace and have businesses running the way they were a year ago. So that will not fly. So again, I think a lot of employees don't understand that if precautions are taken, it's safe to return, or as safe as possible, and the employer's done what they need to do, they must return. They have an obligation to return, so they don't get into a potential job abandonment scenario.
Okay, so what do employers have to accommodate? Marnie touched on this, and I'm just going to elaborate on it a bit. So when it has to do with family status, so family status is a protected ground under the Human Rights Code. So here are all the grounds of discrimination, but basically, I'll just move it to the next slide. And what is a family status? Employees can allege that, or can say that they need accommodation due to their family status. If they're needing to stay home, if they need accommodation to take care of their kids or any other family member. And family member means the status of being in a parent and child relationship, but that is really interpreted quite broadly. So it may not be based on blood or adoption ties, but it's a relationship that's based on care, responsibility, and commitment. That's really what it comes down to. And examples include parents caring for children, which includes, obviously by adoption, by fostering, by step parenting, people caring for aging parents or relatives with disabilities, and families obviously headed by lesbian, gay, bisexual, or transgendered persons. So it's not it's interpreted quite broadly when employees say they need accommodation for family reasons. It would fall under the family status ground of the Human Rights Code. And then what that means is that employers do have a duty to accommodate. So they have a positive duty to accommodate up to the point of undue hardship. And what is undue hardship? It's always the big question that employers ask. And the Human Rights Code sets out only 3 items that may be considered in assessing whether an accommodation would cause undue hardship. And those items are cost. So you would look at cost, outside sources of funding, if any, and health and safety requirements. So it's often difficult. Sometimes employers, allege, and they can allege that they have accommodated up to undue hardship, where it's become cost prohibitive, where they've tried to get outside sources of funding and they've reached the max on that. And if this health and safety requirements make it no longer possible to further accommodate, that's what employers can argue in order to just say that the accommodation is no longer possible. Okay, and so what would happen, if an employee asserts the need for accommodation, that could involve, all the things we mentioned: need to work from home, need for time off, need to work part-time, etc. The employer needs to ask why, and needs to ask the employee to substantiate the need in order to gather more information. So employers have a duty to engage in a meaningful conversation with the employee on the accommodation. Employees are not entitled to the accommodation of their choice. So, even though an employee is saying, I absolutely, I need to be accommodated and work from home, if that's not possible, employers can, like I said, engage in a conversation and figure out how accommodation is possible, and that might involve a different type of accommodation and not necessarily working from home if that's not possible. And the employer and the employee need to work together to see what accommodation can work for both parties. And as I mentioned, the employer must accommodate up to the point of undue hardship. And what would happen if there was a failure to accommodate? There are some consequences. So, if an employer is refusing to accommodate whatsoever, or if the employee is not satisfied with the accommodation, there's always the risk that that employee make a human rights application. So the employee would start a human rights application, and then the employer would then have to defend, or the employee could bring a wrongful dismissal claim. So employers really want to protect themselves by ensuring that efforts to accommodate are well documented in writing. For example, requests for evidence, any substantiation, any communications with the employees, and any considerations that have been made on sources of outside funding, etc., should be documented.
I will say on the communications with the employees too, just to have your team, HR, people ops, or whoever's communicating, just to be cautious about what they say to employees and what they say internally too. The communications internally about the legitimacy of a request. People need to be mindful that some of those communications could be produced in a HR2 application or wrongful dismissal lawsuit. So be very careful that you're approaching it with the mindset that we've covered today, and not to write things in emails that aren't consistent with these recommended approaches.
All right, so takeaways. Okay, so we talked about, just a quick recap, the IDEL or similar legislative leaves will provide employees with protection for most family-related needs for absences. Other accommodation requests will likely be protected under the family status ground in the human rights legislation. As employers, make sure to ask questions, be flexible, and write everything down. So I don't know if we have any questions. Let's see.
I'm just taking a look here.
Do you see any questions? I don't see any questions, which would be a first, I think. Oh, no, we have some questions. Okay. When asked, staff are saying that their fear is related to taking public transit. Okay, so if I guess you're asking, if an employee is I'm guessing, you're saying employees refusing to come to work and saying that they're afraid because they're afraid to take public transit. Again, that would go to just, the duty to engage in a meaningful conversation and see if there are any alternatives. Can you accommodate that employee and allow them to work from home? Is there any other way they can get to work? Can you modify their hours where, public transit isn't as busy at those times? There's a lot of ways to accommodate, but again, as we mentioned, the employees are not necessarily entitled to the accommodation of their choice. If an employee has a pre-existing condition that puts them at a higher risk for contracting COVID, is it sufficient for the employer to provide the employee with PPE and ask them to come into work in the office? Again, that's just, it depends. If your employee is prepared to come into the office, and you as the employer have sufficient measures in place to keep them safe, I think that would likely be fine. If you can provide like social distancing and you're sanitizing and they're wearing personal protective equipment, and everyone's wearing masks, it should be fine. But again, if that employee is asking for accommodation, then a meaningful discussion should be had. Marnie,
I think also, yeah, and this underlying condition, pre-existing condition, is very important, and I think it would be very prudent for employers to seek to ask the employee, are you willing to have your doctor explain, you know, and you're not looking for any kind of diagnosis, it's what kind of protections would help with the condition. I think you could get again, it's not a requirement to produce a medical document for the IDEL, but when you're trying to accommodate and understand the person's health restrictions, you might say, are you willing to provide a doctor's note so we can better understand what the underlying condition is and see if we can, like, we think we've checked every box here in terms of safety. There's nobody around, we have plexiglass, we have rotating schedules, and we just don't know if there's more we can do. Can your doctor weigh in on this? And we often will help employers prepare background information for doctors so that they have enough information to make an informed recommendation. And you can say, so-and-so is a valued employee, they've expressed concern about this, these are the things we're doing to make the workplace as safe as possible. Is there anything further that you might recommend given the underlying condition that your patient has? And that might help the process. But again, it goes back to Danielle's, unfortunately, initial comment about it depends. And you have to have this conversation and demonstrate as an employer you've really thought hard about the employee's request, and is there any way that you can come to a creative solution?
Okay, great. Next question. Are employees entitled to accommodation to work from home if it is a choice or preference to not put kids in school? Yes, these employees are still entitled to accommodation under the human rights legislation, so under family status, they would be. And they would be entitled to the IDEL as well, even though it's a preference. Are employees entitled to accommodation to work from home if it, again, the same question, if it is a choice or preference not to put kids in the school rather than a need based on health? Yeah, same answer. What happens in the following case? Don't feel safe despite precautions all in place, want to work from home and have all the programs, etc., to work from home. Yeah, I mean, it's similar answer. You would want to understand why. Why do they not feel safe despite the precautions? Why do they want to work from home? Is it really a need? Is there any sort of evidence that they can provide? Although they're not necessarily required to provide any evidence, you can still ask for it. And really engage in a meaningful conversation. And if it's possible to accommodate them by working from home, you know, it's really a case by case, you know, something that you as the employer would decide after having that meaningful conversation. But I would say, you know, you can determine that other ways of accommodating are sufficient enough. Marnie, I don't know if you have anything to add there.
No, I think that's a thorough. Here's another one on doctor's notes. For those claiming they are not well, can we request doctor's notes? For some, this has been difficult as they don't want to enter a doctor's office at this time. And I think that's probably one of the reasons why you can't require, as an employer, you can't require a doctor's note. And so I think the answer is, again, this conversation about checking in with the employee and, you know, on a reasonable basis without sort of harassing the employee, but you're trying to run your business and understand who's going to be available. And it's just, again, a dialogue about when, you know, do you know when you might expect to be returning? And sometimes they might not, but you can't demand a doctor's note to support the IDEL.
Right, exactly. Yeah, you can request it, but you can't require it.
Mm-hmm. Yeah, and the employee might be fully willing to do that, prepared to provide the note, and we do see that, and then it's a more seamless situation in that case. Yeah. Challenging for employers for sure.
In a context where employees are working from home, what is an appropriate response to a request from an employee who would like to work remotely from a different country to be with family during COVID, without there being an explicit caregiving duty between the employee and the parents? This is really something that as the employer you'd have to discuss with the employee. You know, whether it's an explicit caregiving duty is, you know, they may argue that there is an explicit caregiving duty, you know, and you can ask more detail on that. And see, you know, if that accommodation is possible, then, I mean, the risk of not accommodating is that the employee would potentially start a human rights application, right? That's the risk here. So you want to do what you can to avoid that risk.
Yeah, and I think we are seeing lots of these kinds of requests with folks who have family out of province. And again, it's really having a conversation with the employee about what that would look like, and could they get the job done, and if in this scenario, and what would help them be able to work remotely, and really nailing down sort of targets and things that would help them succeed in their role from a remote environment. I mean, our firm is we promote virtual work regularly, and going in eyes wide open and figuring out a plan means that you're setting your employee up for success in at the outset. So really considering whether this is possible. It's just not possible for some workplaces. So the conversation might be an easier sort of conversation at that point.
Mm-hmm. Okay, the next question. IDEL eligibility seem very broad. Can you give some examples where IDEL would not be available to an employee? Yes, they are, and they've become even more, they weren't as broad about a month ago, and they've become more broad. So, I mean, if it has something to do, if they're requesting a leave and it has to do with COVID-19, basically they're pretty much entitled to it. But I mean, I recommend that you just Google IDEL, infectious disease emergency leave, and it goes through very in a detailed way how or which employees are eligible. I would say they might not be eligible if the reason has absolutely nothing to do with COVID-19.
Check out the link on slide 9 of the presentation that has the link to the Ministry of Labor reasons for an employee may take the IDEL.
Right. Okay, we have a few more questions. If an employee chooses to work from home because of childcare, homeschooling of children, but their role is impossible to do so at home, are we required to provide alternative work, or do they just go on leave? If you're able to provide alternative work, you can, but I mean, a leave may be a form of accommodation if nothing else is possible. If you're not able to accommodate that employee any other way, a leave, the leave is appropriate. If you want to provide alternative work and you're able to, that's great. That's a great form of accommodation, but it's not necessarily required. But the thing, if the employee were to bring a human rights application or something, then that employee might be able to argue that it was possible to be accommodated in different ways. So again, it's really just talking to the employee and seeing what's possible and what's not possible.
Back to the question, we have a number of employees working remotely. If they ask to work remotely in another province or country, is there anything we need to be mindful of? Yeah, there in the employment standards legislation in various provinces has specific applications, and it depends on how much time the employee is spending in the province and whether they're just temporarily out of province but returning. Then for example, BC employment standards legislation would apply, or the Ontario ESA would apply. So you have to look at how long they're away, if this is just a temporary relocation, and to make sure that you check the particular legislation to make sure it still applies to the employment relationship.
Okay. I think that's all the time we have for today.
We were, yeah. Yeah, we have quite a few questions, but we were able to get to a few. But thank you to everyone for joining us today, and we're certainly available for more detailed questions if we weren't able to cover topics today. It looks like there's so many issues we might have to do another webinar on the same topic as this evolves.
Yeah, exactly. Feel free to be in touch with us, and you will be receiving the slide deck and the link to this webinar by email within the next day. So thanks again for joining us, and take care and have a great day.
Have a great day, everyone. Thanks for joining.